Okay, there we go. All right, good, good. Is my screen two up?
We see the
Charles,
screen, you're good.
perfect. Okay, slideshow.
And we are recording, by the way. So.
All right. I don't see the record. Oh yeah, there we go. Perfect. Thank you. Thank you, Charles, for hosting this. You know, South Florida Hospital News continues to be the leader in this industry of bringing interesting topics, making them available to the healthcare community in general. And I really appreciate your part in making information accessible to everyone without having it be something, number one, that costs anybody anything, or that is hard to get to. And you know, the point of our presentations is really to help bring substantive topics that are on point, that the healthcare industry is being affected by. And if it's got a legal angle to it, we will do an actual seminar on it because it's important to the community. So with that said, today we're presenting how W-2 employees differ from 1099 contractors, and what to think about if somebody's transitioning out of a W-2 environment into a 1099 environment, like an independent contractor. So today we'll talk about some critical elements like the strategies and strategies, tax ramifications, and what to look for in contracting. But before we begin, just to give you a quick short story, think of a consultant or a laborer or a physician that's actually a contracted employee but does not work as a W-2 person. Again, it could be a laborer, it could be a physician, it could be a computer consultant. If you think of it in that context, we've had situations arise where a person who was working for a particular company as a contractor gets terminated. And once they get terminated, they go and claim for unemployment. When they claim for unemployment, the state will usually ask, like the Department of Revenue will usually ask, why are you doing this? Like, why do you think you're entitled to this? And when they find out that the person was acting as an employee of the employer, it triggers a state audit. So like the Department of Revenue will conduct their audit in the state of Florida. It's done by the Department of Revenue. And it can also trigger an IRS audit. And what that does is then the reason why the state and the IRS want to audit such an employer is because there's taxes on the other side of it. There's Social Security, there's Medicare, there's Social Security, Medicare, workers' comp issues, things like that, that a typical employee would have, and even healthcare benefits, right? So the state and the IRS will get involved as soon as something like this gets triggered. So as we talk about this today, I want you to keep this in mind that we're doing it to help you navigate through these different circumstances, whether you're an employer or the consultant on the outside, or even an employee on the inside, but this primarily pertains to consultants on the outside. So a little bit about ourselves. Oh, by the way, before we go on to the next page, just keep in mind that today's presentation is intended as a general informational session. It is not legal advice, and that the seminar is an open, live, and being recorded forum, and it's going to be used online as a recorded resource later on for people to be able to get to it. So it'll go on South Florida Hospital News channel, as well as our law firm news channel. Okay, so a little bit about ourselves before we begin. My name is, again, Ben Assad Mirza. I have been a litigator and an attorney for about 20 years now. Actually, April makes it a full, complete 20 years. And I have several degrees. One of them happens to be in accounting. One of them happens to be an LLM of tax. And I also happen to have a master's of public health from Yale. And I've been employed in a bunch of different places, and you know, been an entrepreneur for a good part of my working life. With that said, let me talk about somebody a little bit more interesting. That's Ed Meyer. Ed has got a well-storied background, very rich. in texture and in context and where we are today. So Ed,
Yeah, thank you. Yeah, well, I'm Ed Meyer. This June 6th, I'll be celebrating my 30th year of law practice, formal law practice, I should say, licensed law practice. I'm of counsel to Healthcare Law Partners. I'm licensed in California. I'm a California licensed attorney. Georgetown for my law degree, actually in Stanford undergrad, studied law while actually working full-time in the Reagan administration at the U.S. Department of Health and Human Services. Over my course of my almost 30-year career, I have worked in various settings representing from large hospital systems, nonprofit systems, to investor-owned systems, to representing individual physicians, individual licensees, to large national medical groups. I just recently was at Mednax out of Sunrise, Florida, in their Texas office. I am very glad to be here, very glad to provide your advices. But as I'm not a litigator, I am a healthcare law practitioner. As they say, I get lost on the way to the courthouse, which is actually true. I've actually gotten lost on the way to the courthouse. But with that, let me introduce you to our associate Komal Mirza.
Good afternoon, and thank you for the introduction, Ben. My name is Komal Mirza. I am actually Ben's niece, and I have been practicing law for quite a few years now. Prior to joining Healthcare Law Partners, I was with Legal Aid Service of Broward County, where I represented foster care children in their medical rights proceedings. I also currently practice in the areas of employment law and business entities, helping create private practices for physicians and healthcare providers. On that note, this presentation should be very interesting for those of you who want to learn about the differentiating nuances between a W-2 employee and a 1099 independent contractor. And with that being said, I'd like to turn the presentation over back to Ben.
Thank you. Thank you. All right, so let's starting off with market forces. We always start off with what's called market forces in our presentation as to what is affecting the state of economics and where we are today. So looking at the unemployment rate, and I think that's for me, it's the actual litmus test as to the foreseeable changes that are coming up. Just in the last 12 months, we went through unforeseen levels of unemployment, definitely in my lifetime and probably ever. It had reached a peak that was well above 14%, and it has now simmered down, as you can see here. It's now close to 6%, and it's dropped a bit. But what has happened now is that the technology curve has actually intervened in the middle. The technology curve is going to cause a lot of people to rethink work and how they do work, obviously. And that's going to affect the way we contract with people on how they will provide services. So are we going to contract with people as employer-employees? Are we going to contract with people as contractors and clients? Or as an individual contractor working with clients, or as a whole entity to entity doing B2B work? So in a majority of this presentation, we're going to talk from the context of the consultant, the independent consultant. So as an independent consultant, people have to think through, are they going to go in as a W-2, a 1099, or create their own consulting firm or company that will work, that'll be the agent of delivering their work?
And I keep in mind that, with the market forces too, what's happened over the last year, a lot of people have been working remotely out of their homes, and they're starting to like it. I mean, some of them are starting to like it. In fact, I just got back from Savannah, Georgia, where I was actually on a different location, but working remotely. That pushes a lot of folks to think, hey, can they be an independent contractor? Can they change their status from employee to employer? But in this discussion, we're gonna talk about the pitfalls of that and the cautions to deal with, and has been also mentioned the contract issues if you're actually moving from an individual into being an employee. I'm sorry, an independent contractor from being an employee.
So, all right, so today, this is our three-part objective. One is we're going to talk about the kind of strategy you can use for employment and compensation purposes. We're going to talk about tax ramifications and what they mean to you and how you need to navigate those. And third and last but not least is contractual terms. We're going to talk about contractual terms that we as insiders see as being important and important to negotiate. And these are the legalese of what you want to be careful of. So let's get started. So let's talk about strategy and how a contractor can go about getting compensation. So compensation generally comes in these three forms, and then you can actually do a blend of the three. Number one, it can be an hourly rate, right? So as a consultant, you can charge, let's say $100 an hour per hour, however many hours it takes to do a particular job. The other way to do it is obviously a fixed fee amount, and you can have a fixed fee amount over either on a monthly basis, on a milestone basis, or a complete project basis. So under fixed fee alone, you can have multiple different variations of that. And the other way to also look at this is you can get compensated as a percentage of revenues or percentage of gross profit realized. So it's kind of like gain sharing. Whatever one company gains, so does the actual contractor working on that. So it's kind of like how you'll see in the healthcare reimbursement insurance industry and the ACOs are doing. Similarly, what we're suggesting to you is there's multiple ways to look at compensation. And for us as a firm, we do look at variable ways of getting compensated for the work that we do. And it can be any of those three fashions. So compensation can take on its own form. Think about what is best for your product, your type of product and the kind of clients that you're catering to. Some clients are very, very difficult to deal with. And when they're difficult, I think you want to stay more towards the hourly. But some clients are very much results focused. With those clients, you may want to take a look at the realized revenue or the realized benefit to the client and taking a percentage of that. So there's different ways to look at compensation, but that's
keep,
your.
Yeah, but I'm sorry, but keep in mind too, as healthcare is a regulated business, so there are different ways, but always if the person is has the ability to generate business reimbursed by the federal healthcare programs, or make referrals over that compensation, you're going to have to want to look at very carefully to make sure it's fair market value and that it's not the volume or value based on the referrals. It even extends to marketing arrangements where the marketer can actually generate business for y'all, and you want to make sure that you're compliant with the healthcare regulations. So there are various ways to pay people, but those ways can also be affected by the regulation of the industry.
That's a good point, Ed. That Stark interjection is an important reminder that what you just said.
Yeah.
So thank you for doing that. Yeah. The other thing that you want to look at is control over the work product. Who's got actual control over the work product? Meaning, like if you're a physician, what do you have control over? If you're a computer consultant, what do you have control over? So let's take the example of a computer consultant. Or more specifically, a computer programmer. Let's say that you hire somebody who is a computer programmer and something along the way goes wrong. Okay, so there's a software that the computer programmer develops, and then it gets used to store information, patient information. Now, who owns that piece of product? Who's going to own it? Is it going to be the person who actually created it? Is it going to be the person that paid for that creation? Or is it going to be some other variation of that? Sometimes the end users end up owning it. So, depending on who your end user is, maybe not a patient, but maybe there's an in-between provider that's there. So who's going to have the ultimate control over that work product? And sometimes people who are paying for a particular product don't want anybody else to be able to use it. I mean, I've negotiated quite a fair amount of contracts where the person that's actually paying for it, the entity, will not want their product out in the open marketplace. And so they may require that the computer programmer destroy the actual copies of that same product that they have and not use it again. Then again, you have to go with a highly reputable person who will not use that work product for their own use, and giving full rights to the person who paid for it in that situation. The other thing you want to think about is the liability aspect. So given the same scenario of the computer programmer, a program is created. In the end, a patient is affected because somehow the software did not assimilate properly, or the data points didn't get through properly, or something wasn't converted from a text value to a numerical value. If something like that goes wrong, who's going to have the ultimate liability for that? Is it going to be the user themselves? Maybe in that case, it might be the patient. They take on the risk that they take on. Or is it going to be the healthcare provider in the middle? Or is it going to be the computer consultant that actually developed the program? Who's going to be ultimately responsible for that kind of liability if something does go wrong with that software? In the same way, you can think about all the other issues, right? So like for us, we deal in agreements all day long, and we deal in cases, litigation. So who's going to take the ultimate responsibility in that? And we have to think about those issues. So in the healthcare environment, it's going to matter who takes on the liability. Let's talk a little bit about tax ramifications. So as a consultant, will you operate as an individual or as an entity? And really, it depends, right? So if you're thinking about a short-term stint, you're probably going to lean more towards operating as an individual and not as an entity. But if you do decide to take on the work as an entity, making it more of a B2B sort of a connection, you've got other things to actually think about. Are you going to rent an office? Are you going to use your home office? What's going to be your deductible expenses? It makes a difference. On an individual level, if you actually claim certain expenses, you carry a higher risk of being audited. But if you do it as a company, maybe that risk gets lowered. And depending on how you're doing your taxes, that also makes a difference. If you come in as an individual, you've got to file at least quarterly taxes. As a company, you're probably filing monthly level taxes because you're going to have payroll involved in it. So think of it in those terms. What kind of tax ramifications do you have if you operate as an individual versus a company? And keep in mind that if taxes are not paid, which is a big part of the lesson for today, if taxes are not paid, there's going to be a lot more at stake. There's going to be like Social Security, Medicare, and unemployment taxes that haven't been paid. So not only is the person who employs the individual and uses them as a 1099 contractor going to have to pay all those things, but they're also going to be subject to the civil sanctions or civil penalties. And it can be sizable. If you take a look at our website, we actually have a 20-point checklist. If you want to know what the IRS or your state is going to audit you for, that 20-point checklist will tell you, it'll walk you right through the actual 20 factors that you need to be aware of and keep at top of mind when you're structuring these relationships. And you can go right to our resources page and it'll be there. And we can email it to you as well. But the 20-point checklist is really, really a nice gauge of whether a person is qualified as a 1099 contractor or as a W-2 employee.
Yeah, and we can't stress enough if you're misclassifying someone, why it's so important to look at that checklist and review the checklist and make sure that the person is appropriately classified. Because as Ben said, there are significant penalties, such as $50 per W-2 not that the employer failed to file on each employee, 1.5% penalty on the wages that should have been paid but weren't, 40% of the FICA penalty on the FICA taxes that were not withheld, 100% for the matching FICA taxes the employer should have paid. And also there could be claims for unemployment benefits, claims for health insurance benefits of the person saying, look, I really should have been classified as an employee. I am eligible for your health insurance. In fact, I'm eligible for your 401k. I'm eligible for your stock purchase. because I should have had it as an employee because I was misclassified. Perhaps if you're doing two on a large scale, there could be a class action lawsuit on behalf of all individuals misclassified. So again, make sure you're classified employees correctly versus independent contractor correctly, because it could be quite a large set of penalties, workers' comp penalties, and disability penalties, and all that sort of stuff.
Yeah.
For if the person should have been an employee and was misclassified as an independent contractor.
Good point. So, when you're about to contract as a consultant with a company, approach it with a healthy level of skepticism. This is the thought process that they teach us as lawyers, to think about everything with a healthy level of skepticism, not overly grudgingly, but at the same time healthily, because you want to make sure that you've uncovered everything that you should have been uncovering, and ask questions about it. So what you really want to do is you want to take a look at the product that you have, that you're going to be producing. You want to take a look at the what. What are you actually delivering? What are you responsible for? And making sure that what is sufficiently defined, especially if you're not just building widgets, right? The widgets is an easy part of something. But if you're providing services, you got to take a look at the what. What are you exactly delivering, and to what level are you responsible for delivering of those services? And it's going to make a difference as to how your client perceives you as well. Are you going to be the complete solution, or just a partial solution to their whole entire program? And then what you want to look at is what is being exchanged for those services. Is number one, are you getting money in return? And what are going to be the actual delivery terms? Is everything going to be delivered within a set of 2, 3, or 5 days? Or does it take a prolonged amount of time? Is it going to, are you going to get compensated based on, again, the milestones, or on an hourly basis, or the full complete project basis, or even as a percentage of revenues basis? So what's being exchanged, you got to understand that. And these are just practical questions, right? So do trust your instincts when it comes to this. When you're dealing with the opposing side. Do take a look at what your worst case scenario is. Like, let's say you do everything that you do and the other side does nothing. Where does that put you? What is the worst case scenario? Will you have so much skin in the game that you can't walk away from it? Or can you walk away fairly even-handedly? And I think even-handedly is the key message here. Whatever relationship you do strike, you want it to be fairly even-handed. That even-handedness is going to go a long ways. It's going to show fairness to the client. It's going to show fairness in court should something go the wrong way. And remember, always do pay attention to the people that you are about to contract with in terms of their reputation, their licenses, the permits that are required, the insurance policies that are there. And the reason why we list all these things is because licensing and insurance and permits and the longevity in the game and the reputation makes all the difference in the world. Because a license will always tell you what is at stake, that a person can be disciplined just based off of the actual license, right? So if it's your license that's in the mix of what is being delivered and it's at risk, then make sure that you promise the things that you can actually deliver and not go overboard. And conversely, the other way as well, whose licenses are on the line. So in the case of like that software that was developed by a computer consultant, obviously the computer consultant's license is not what's on the hook. It's going to be the end physician's license that's going to be on the hook, right? If something doesn't go right. So you got to take a look at the skin in the game and just use your instincts. Understand how to spot a con artist. One of the easiest things that I do is whenever I'm talking to somebody and I'm not so sure how trustworthy they are, I will ask questions forwards in time and backwards in time. Just ask them whatever it is. You could talk about their business, you could talk about what they do, how they got educated, and you talk about it forwards in time, and then you take them backwards in time. And if the story remains consistent across the spectrum, going in both directions, then you know that the person's telling you with sufficient clarity that you can believe something. That doesn't necessarily, there's good liars too. So just keep that in mind. And you laugh.
Yeah. No, I was going to say was over my career, I have either represented or been the other side of embezzlers. One of the things about embezzlers, and if you look at the Bernie Madoff example, is they're the nicest people because that's how they get people's confidence. Is they're very nice. They start giving things for free to the individual they're contracting with. Um, they start doing favors, but what they don't do is they don't meet the checks and balances that the astute contracting person or the person employing them will constantly should be checking on. But that's how they get away with what they're doing is they get the confidence in their person saying, well, gee, that person's so nice. Of course, they're not going to do anything wrong. Well, that's how they get away with it for persons not really inquiring and asking and looking into the background and checking the licenses, checking it. Because actually, look at the Bernie Madoff example. He did not have one of the key licenses required for what he was doing. He was hired to do. I don't think you need a license to embezzle, but he did not have the key license necessary. So again, if just have your checks and balances and stick by them with regard to checking out the person you're contracting or the person that you're employing, especially if they're handling money or have the ability to have access to funds or billing.
And you bring up a good point about making sure to do complete background checks on anyone that you're employing as a W-2 or as a 1099. Florida statutes actually require that all employers complete a level 2 background check on their employees that are going to be coming into direct contact with people of vulnerable populations like children or the elderly. So it is actually, not only will it help in terms of figuring out whether you're hiring a reliable and trustworthy person, but it'll also help make sure that you are shielded from any sort of liability in regards to your level 2 background checks.
That's a good point.
Ben, we do have a question that came up. It says, are 1099 employees eligible to receive workman's comp?
Not if they're 1099.
Not if they're 1099. They're outside.
Well, again, that's but what they would do instead is they would perhaps set up a corporation and seek to have that corporation pay the correct workers' comp, arrangements, taxes to be able to be eligible through that entity, but not a 1099 employee does not. A 1099 individual is not. That's separate. They're not an employee.
And Ben,
And also in the state of Florida, it's
one other question is there I know I've seen it in my career, kind of a checklist to differentiate between an employee and a 1099 person, because sometimes you think the person is a 1099 person, but they don't meet the criteria, and they want to be treated as a 1099, but they can't be because they're really a W-2 employee. Can you go into that?
Yeah, so we actually have a checklist on our website on the resources page, and I'll stop here for just a minute to kind of share that with you. If you give me a second, I'll pull it right up. Here it is. This is the actual checklist that you'll see on our website, and so in here, this is considered the IRS's 20-point control factor test. And it talks about instructions, who's giving the instructions, who's training the employee or the consultant, right? And they look at things like, are the services being personally rendered? Who's doing the supervising and hiring of the person? Who's paying for the assistants that are involved in the job? Who's setting the work hours? Who's providing like the investment or the tools that are going into it? This is a full-on 20-point, test. And these are the kinds of things that they look at. Like here's the significant investment test that they look at. Who's providing the actual tools that are involved here? Who's realizing the actual profits or losses of whatever is being produced? You want to
work schedule. Work schedule is another one.
Work schedule. Yeah.
Is the company hiring this person setting their work schedule, or can they come in and do it as they see as an independent person would see fit to do their work?
Yeah. So that's a good question, Charles.
Yeah, and one thing to
you know, down
mention,
here,
I do want, I do want to mention that if someone's doing some internet research on that, they may see that at the last few weeks of the Trump administration, they had passed or floated some liberalization of these tests on 1099 versus employee. But the Biden administration, when it got in, it basically rejected that, and so it's the current status as we have now. They have not, as Lisa said a couple of days ago when I last checked, have not made any changes, the Biden administration, to the tests for employee versus worker, independent contractor.
and if you guys stick around after this seminar, we're going to talk about Biden versus Trump scenario, and we're going to talk about religion too. So.
No, it's
The,
good.
the other thing I've always looked at relating to this is being control and how much of a control you
Yes.
have over the individual. If you're exhibiting a lot of control over the what they do, how they do it, and that type of stuff, it seems to be more of an employee than a 1099 person. Would you agree?
Right. I would agree with that. Yes.
This one factor that basically says, is it an exclusive arrangement, and are the services being offered to the overall general public? Are there services for hire by multiple companies? And if they are, then it starts to look less and less like an employee, frankly. You know, the consultant truly starts to look more like a 1099 consultant, because now they're working for multiple employers at the same time.
And also be very careful if the person was working as an employee of the company, and then abracadabra, the next day the company reclassifies them as an independent contractor, and there's just really no change, because that really sends a red flag, especially if the IRS is going to get two documents, a W-2 and a 1099 for the same tax year from that same corporate entity, and they're going to go, well, what really happened here? So that's just be very, very cautious if you're reclassifying an individual who's currently employed as an independent contractor without really changing what they were doing prior to that change.
Yeah, that's a good point. Next, here's a pretty big sort of a picture of a water heater, and I'm going to give you a short story on this because it's going to drive home a bunch of points that we're going to touch on next. We had a particular situation arise where there was a condominium building that engaged us as their attorney. What happened is they actually had this water heater replaced inside one of their water heater closets, and they hired, and this was a 15-story condominium building. They hired on somebody that was a plumber or presumed plumber for $500 to change out a water heater. Well, when the guy comes in, he pulls up with his van, takes out the water heater, goes up to the 10th floor with the water heater, takes it down the hallway, and opens up the closet to put this water heater in. When he does this, he's working with the pipes, trying to connect them, right? As he's trying to connect the pipes to the water heater, there's another pipe right next to the water heater. And what he does is he happens to hit it and break it. When he breaks it, he then realizes that the water's gushing out there with such velocity that it's really water that's being pumped from downstairs all the way up to the roof of the 15th floor for an air conditioning chiller. And because it's got so much pressure behind it, the water that's coming out is not just your average water. It's got a lot of pressure in it. And so the water comes out of the water heater closet and starts to go down the hallway, and it goes to the left and the right and starts drenching all of the units there. And as it makes its way up to the elevator doors, there's kind of a slump, and it starts to go down into the elevator wells, right in where the doors are still closed, but the water's going in. In the meantime, the elevators are going up and down in their whatever you call them, I guess silos, right? Kind of like the silos. They're going up and down within their silos or their tracks, and they're getting drenched. And the ropes that are the steel ropes that they use, they're also getting drenched. As they go below, the water goes to the inside of the elevators and blows their control panels. Now, mind you, these are fairly old elevators with highly specific parts. And if any of you guys know much about elevators, they are very unique to the manufacturer that makes them. So if you want a replacement part for an elevator, you better order ahead, like way ahead. So the elevators go down, there's a lot of people in that building, and now you cannot go up or down without an elevator. So what are you to do? So here's a $500 water heater turned into $500,000 worth of damages. So when they came to us, we wrote these people a letter. We sent them stuff on it, demand letters, and nobody answered. Nobody answered. We gave it a few more days, and then we filed a lawsuit. When we filed a lawsuit, we heard back from another law firm. It was a fairly reputable law firm. And when we heard back from them, that's when we realized like there was an actual insurance company behind it all. So in that particular situation, they went from a guy that was a plumber who was not known to them at all. Nobody knew him. Nobody knew whether he was licensed or insured or any of that sort of stuff. They didn't check his background. They didn't do anything. Now, by no stretch of the imagination am I telling you that for a $500 contract, you need an attorney to review your contracts. But what I am saying is, even when you're entering into a $500 contract, and as small as it may seem, you've got to take a look at it with a healthy level of skepticism. And when you look at it with a healthy level of skepticism, you've got to think about the worst case scenarios and what kinds of things that may befall from that transaction. Ed, you were going to say something?
Right. No, I guess I was going to say, in the key, what's the worst going to happen in this case? They're working with pipes, you can burst a pipe, right? And so even though it's $500, are you checking, do they have insurance? Is there a contract? Is this person bonded? Is this person reputable? Because things can go south. So doing that just general check and making sure they have insurance, and the insurance is adequate for any potential damage that were done. That's just a key thing. And that's why it's also important to have contracts in place to describe what your obligations are, and read them and look at them.
Yeah. So today's discussion is really about what to look out for. So with us, when we look at contracts and we review contracts, we're looking at the parties. We're looking at specifically who the individuals are, what the companies are, if there's any guarantors or licenses in play. We want to always verify those. So knowing the parties, knowing that they're a legitimate, legally filed entity is really important before you contract with them. Identification of parties specifically, knowing their addresses, their phone numbers, knowing who their insurers are is important. So keep that in mind when you're going to contract. The other thing to keep in mind is when you look at the term of the contract, meaning the number of years that it's for, there's contracts that can go on for 10 years, but they may have an annual renewal that can go on for 10 years. Then there's contracts that are non-cancelable ever. Then there's contracts that can be canceled within 30 days, and it may be a 30-year contract. So, you got to really think through the terms of the contract. Now, the one thing that you should keep in mind is when you're dealing with a public versus a private entity. A private entity can enter into a multi-year contract, but if you're dealing with a public entity, the general rule of thumb and the statute, the state of Florida has a statute for public entities, meaning a governmental entity, that they cannot contract for more than 1 year at a time. And if they do, it's always contingent to a cancellation, because what the government doesn't wants to make sure is that nobody's being promised a revenue stream in perpetuities when the tax dollars may not show up year over year for the following years. So the state of Florida has a specific statute for all governmental entities, including health systems like a Jackson Memorial or a Broward Health or any of these other systems that you do see around, or Lee Health, right? That they cannot contract for more than 1 year. And if they do, it's going to be cancelable. Just know that. So it's not a for sure revenue stream for the entirety of multiple years. It's only for the 1 year at a time.
That's actually an important point to keep in mind for lawyers, because employees oftentimes run into trouble, or even contractors, with that, forgetting the 1 year limit.
I can see that. I can see that happening. Now, the other thing to keep in mind is liability and liability insurance. So again, thinking about what can possibly go wrong. Who's going to be ultimately liable, right? So let's take the situation of the software consultant who develops that software. In there, are you going to make sure that the person has professional liability? Is it going to be the consultant, the computer consultant, or is it going to be the physician using that software? You know, are you going to have a directors and officers insurance? Are you going to have a DNO stands for directors and officers, PD stands for property and damage, and PROF stands for professional liability. Are you going to have these different types of insurances? They're not all necessary, but some of them are very critical, right? So even like, for example, cyber insurance, it becomes really important depending on where you're storing that data in that sort of a scenario that we're talking about. You might want to have cyber insurance because, you know, the person who developed the software developed it, but now as a provider, you're responsible for storing that stuff, right? So cyber insurance will come into play when you've got potential HIPAA issues, you know, things that are not secured properly. The other thing to think about is also workers' comp and general liability. General liability is kind of like the catch-all of everything else that kind of goes wrong. General liability will pick it up. But general liability cannot always be relied upon, especially if there's like a professional liability claim in the middle of it.
Yeah, and keep in mind too, I guess one thing, you know, sort of interesting, you know, pro and con is you want to make sure that those insurances are all in place to the extent you need to make sure you're fully taken care of. But including a listing in detail of all the insurance in a contract can also provide a potential litigant who gets a hold of the contract in a lawsuit to know where all the money is, and then to file claims based upon, oh, I got oh, you got cyber? Okay, I'm gonna find a way to file a cyber claim, or you know, you got property damage, or all these other insurances and the amounts. You know, so if they're in the contract and somebody gets a hold of the contract, it's sort of it's a menu of where the money is in litigation. But obviously, you want to make sure those contracts are, those insurances are in place if there's liability there.
Now, talking a little bit about limitations of liability and indemnification clauses, us as attorneys, we tussle a lot with those sorts of provisions. And I'll give you a real life example of how limitations of liability works or indemnification works, right? So, for example, if any of you have ever bought a house, you've always had it inspected, right? The inspectors will go in and inspect the house. When they go in and they inspect it, did they inspect the plumbing the right way? Did they inspect the roof the right way? Did they inspect the electrical the right way? If they didn't, you know, to fix each one of those things can be a sizable, costly proposition. So like, for example, a roof on your house might be anywhere from $20,000 to $40,000. And $20,000 if you have a regular small size sort of a house, you know, based on a shingle. We're not even talking about real roof tiles. So, you know, so when the inspector goes in to inspect the house, you'll take a look at their report. You'll see the contract that they actually attach to the back of it. Sometimes and I think it's not enforceable, but what they will say in their contracts is sign below. Should something go wrong, let's say they forgot about the roof and the way they inspected it, they didn't walk around and they didn't look at it the right way because now the whole entire roof needs to be replaced. What'll happen is it may be a $20,000 claim that you have against them, but in the contract it says, I will reimburse you for whatever I fail to uncover, limited to the amount of fees that I charged you. So you get that? So like the inspector has now charged you, let's say $300 to do the inspection. The roof is going to cost you $20,000 to replace because the guy forgot about it. But now he says he'll pay you $300 back because that's the amount of the fees that you paid him. And that's his limitation on liability clause. It's a pretty smart way to do it, but it's pretty bad, right? You know, especially for the person that's getting shorted all that, shorted that whole, you know, $19,700 worth of the loss. So, you know, most inspectors do carry insurance, and I think they carry specifically for that purpose when something like that is missed. So
I see there's a question, by the way. You see there's a question from that sometimes the scope of work changes. What should consultant be mindful of, and how can your firm help navigate those processes?
yeah, so it always for us to navigate that process, it always starts off with what's the end product in mind. And it's going to vary. If you can actually elaborate as to what that is that you're kind of talking about, maybe we can talk about it here. But I do see it's 12:50 already, and I think we'll have about 5 minutes we can touch on that. So yeah, there's different ways to set it up, Maria. The next thing to keep in mind is for us, what we do is with every client, we make sure that there's one mouthpiece. Although it's going to be whatever they decide on behalf of the company may be done by multiple people, but there's only one designated person that really speaks to us of that, of whatever job they give us. And in the same way, I think as a consultant, you should consider the same. You should think about having one representative from the organization that you're consulting with talk to you directly. And the reason why we say it is this. Oftentimes when you have governance by committee and everybody's entitled to their opinion, and in talking to you as a consultant, they all have different versions and different opinions of how something should be done. So what you want is, you don't want to take commands from a bunch of different people. Otherwise your job will never end. You'll be frustrated and they'll be frustrated because nobody will be happy. You've got to let them develop a consensus within their own organization and have one person that speaks for them. So make sure that whoever you engage with has the authority to speak on behalf of the organization and has a sufficient know-how to understand what the topic is, or the subject matter is. It becomes hugely important. Some people will actually elaborate who that person will be, the channel of communication with the back to the consulting firm. So, Maria, if you do have a question, you're welcome to also call us up afterwards too. Also keep in mind, termination clause is probably one of the most important clauses you can have in a contract. It's not just the compensation clause. The compensation clause, I think, is still subordinate. To me, the termination clause is more important than the compensation clause, because the termination clause lets you realign a contract. If something is not going right, not going the way you think it should have been going, then it lets you terminate on an even-handed basis, or hopefully it's going to be on an even-handed basis, and get compensated for what you did. Or and at the same time, not hurt the other side too much. It's got to have a level of fairness to all termination clauses, because sometimes what will happen is people are allowed to terminate at any given point in time, but in the meantime, so much pre-work had to be done to get the contract started that everybody forgot about all the pre-work that went into it, because some contracts, believe it or not, are front-end loaded. Some contracts are back-end loaded. So you got to take a look at that. How are you going to terminate a job fairly? So those are some of the things to think about. As you go through the process of legal contracting, if you need us, you're welcome to call us. You can email us. Provided if we don't have a conflict with the entity that you're doing the work for, we're happy to review the document with you and give you an idea of what it would cost to get that contract done the way you want it done. And there is no right or wrong. It's the way you want it done. And so that's how you'd contact us. Below is our contact information. And there's also a resources page that you can turn to, and you can take a look at the handout that we talked about today. It's on there. And if you want us to email you, we can email that to you as well. That's it. That's for good. Any questions?
There you go.
Aha, question. Oh, it's not a question. Thanks.
It's accolades. You got some
Yeah,
accolades.
it says, thank you. Great session. I appreciate you framing the presentation with a description of relationships. Typically, we consultants move forward with work and do not think of the options. You're absolutely right, Maria. The checklist was so helpful. You've broadened my perspective. Well, thank you. Thank you for that.
Thank you very much.
For that acknowledgement for us. Appreciate it. And hey, call us. It's for free.
Ben, why don't you tell us what's coming up on April 20th?
On April 20th, we've got a great seminar. It's going to be about telehealth. As you know, the telehealth has been a big push. We last did this seminar about 6 months ago, and it's going to bring people up to date. Como, do you want to? Because Como is the one that actually leads that one. She, she's the young buck, so she's got to be the technology person that.
Yeah.
Sure. So there have been some changes with telehealth, exceptions and waivers as far as the Department of Health and CMS is concerned. So this presentation is going to be, we're going to be going over what's already been discussed over the last year. It's particularly under the Trump administration, and a couple of the changes that we have seen under the Biden administration. It should be very interesting, and I'll also touch a little bit on what will possibly happen moving forward post pandemic. So it'll be a great update on the legal nuances that we've seen because of the pandemic, and making sure that people are receiving continuity of care.
Great, thank you. And also remember, those that are on, share the links as you get them for the different events. We've made these free to everybody who comes on. If you're getting a lot of emails from a lot of different learning institutions, you're seeing that some of these seminars, the cheapest one that I've seen relating to similar topics is $500. This is you're getting a good update for an hour, well worth a $500 fee, which we're not charging to be able to do that. So please, if you've enjoyed this one, come to the others. It's only 1 hour every 2 weeks to give you an update on what's going on legally. If you're a consultant, not a consultant, you need to know what's going on. Como?
And just to make a quick note on that, we have actually applied for continuing legal education credits for that, and I am anticipating receiving confirmation on those credits for that telehealth presentation, both a general credit and a technology credit. So if you are an attorney, or if you know an attorney that your in-house counsel or your general counsel at your place of employment, please encourage them to attend. They will receive a continuing legal education credit from the Florida Bar specifically.
And the other thing is, in a lot of the continuing education events, although they may not be sanctioned, as most of ours have not been, if you get a copy of the PowerPoint and submit that with a copy of the description, I would almost guarantee that they would give you credit for it. Very in-depth information, but sometimes we don't have the time to be able to get it accredited. We're working on it now, but I would definitely do that, and we can send you the PowerPoints for you to have when you're submitting your credits. So, and with that, any final words from the legal team?
Well, thank you, Charles. I mean,
Thank you,
really,
Charles.
it's great to be all with you. Very, very forward thinking. It's really a benefit
That's
to the
awesome.
South Florida.
The funny thing is, there's a lot of people entertaining this idea of doing the same stuff that you're doing, Charles. I think it's going to be great for our community, because I think that it's really starting to catch up.
Yeah, well, we're trying to provide the information that people need in South Florida. So, and again, tell your friends in other parts of Florida. We're online, and come get to us from anywhere. We appreciate that. Tune in again. We do have a networking event tomorrow morning. You can go to my website, South Florida Hospital News, if you want to get up at 8 o'clock in the morning. The good thing is you don't have to get up at 6 in the morning and be someplace at 8 o'clock in the morning. All you got to do is kind of comb your hair, put on a shirt. We don't care what you're wearing from the waist down, as long as you don't get up, that's okay. And join us. We have about 25, 30 people coming on tomorrow morning, and you'll meet your next business connection. And if you don't want to do that, the next event for the Lunch and Learn, Legal Lunch and Learn, is going to be April 20th. And as we said, it'll be telehealth. And with that, hopefully you have a great rest of the week, and we'll see you next time. Thank you.
Thank you, guys.
Thanks, everyone.
Bye.
Bye.
Thank you, Joe. Okay, bye. Bye, Maria. Take care.